This is Michael Popok. It's After Dark. Do you know where your legal AF is? Did Judge Merchan, the Supreme Court judge in New York, who was about to sentence Donald Trump for his 34 felony count conviction, is he going to send Donald Trump to prison on the 26th of November? Or isn't he? And did the Manhattan DA, the prosecutor, make a mistake in not taking a stronger position in front of the judge that they wanted that sentencing before the election, allowing the judge to push it off until just a couple of days before Thanksgiving? Was that a tactical error? I got the perfect person to ask that of. My co-anchor on Legal AF on Midweek, Karen Friedman Agnifilo, formerly the number 2 prosecutor in that very office, the Manhattan DA. Let's take a listen. The New York Manhattan DA prosecution and where we're at with that. And here's my question. I'll just lay it out there. Merchan had a decision to make. And the way he made it as the sentencing judge, this is now after arraignment, after conviction, before sentencing. Donald Trump was supposed to be sentenced in July. But right before he was about to be sentenced, the immunity decision came out. He's supposed to be sentenced in the middle of July. July 1, the immunity decision comes out of the U.S. Supreme Court. And Merchan, rightfully so, said, you know what? Let's take a break. Everybody brief the issue. Donald Trump asked for a briefing. He's going to file a motion. I need to apply, as a judge who lives in America, I need to apply what the Supreme Court says if it's applicable. Let me see your briefing. So he took time out. He could have sentenced him, but he didn't. All right. Now we fast forward to the delayed date, postponed a second time into September. And in the interim, Donald Trump runs off to federal court, tries to remove the case the last minute, post-conviction, pre-sentencing, to try to argue some federal defense. And he gets assigned, of course, to the same judge, Judge Hellerstein, federal court, that you and I talked about when we were on holiday and phoning in from our holidays on our midweek edition at that time. And they lost then. And they tried to re-argue that he had the right as a federal officer. Donald Trump, employee badge number 1, gets to take all of his cases to federal court, which is not true, and not true based on the allegations in the indictment. And now the conviction in the indictment. In other words, 12 jurors in New York believe the indictment and the evidence that was presented beyond a reasonable doubt. He's convicted. So it's a whole different world. So he, however, looks to the Manhattan DA and says, what say you, Manhattan DA? Should I delay further? Or should I, as the criminal procedure law in New York says, should I have to administer justice. I have to sentence relatively quickly. What do you say? And you and I talked a couple weeks ago about the smart position that they took to say, we're going to be agnostic on this, judge. You know how a calendar works. You know your job. You do what you do. You do you. We're not going to take a position. When Merchan wrote his decision, in which he said, I'm going to delay the sentencing till November 26th, and I'm not even going to rule on the immunity decision until much later after the election as well, tying the two things together and saying, the clock, he interpreted it as the clock doesn't start on my having to sentence until I rule on the motion to dismiss on immunity. So I'm going to postpone both, kick them both over, and then but he did spill a number of pages of ink talking about the Manhattan DA not taking a position. Do you think that was a mistake for the Manhattan DA not to take a position? And if they had taken a position for him to sentence on time and stay the course, do you think Judge Merchan would have made a different decision?
I mean, look, I think they miscalculated. They tried to be too cute by half. And this is my old office. I love them, but I got to call it like I see it. They tried to not take a position and say, we don't take a position. I said several times on Legal AF and on Hot Takes and everywhere else that they were taking a position by not taking a position, which is they were essentially agreeing that it's okay to adjourn the case. And look, everyone who practices law in that building knows that that's exactly what they were doing. And so it was just totally clear, right, that they were essentially saying, look, we agree this should be adjourned, because they just didn't think there was enough time to brief it. And they felt that they needed to say that. And so the judge saw that too. And the judge was like, look, I'm not going to let you put this on me. Everyone's going to get criticized. And, everyone's going to say, oh, this is political, or why are you doing this? Why are you not doing it? And you're not going to put this on me as if this is all on me. You agreed too. You left me with no choice, essentially. So, he kind of called them out on it. and really sort of showed them what they were doing, because that's what they were doing. It was just so obvious, but it's fine. That's what they felt. I think they should have just leaned into it. They thought it should be adjourned. And so just say that. You don't not take a position. They thought it should be adjourned, not for political reasons, but because of this, this dumpster fire of a decision on presidential immunity that the Supreme Court handed down in July. I mean, it was just ridiculous. Does it apply to the case? Is he immune from the conduct? Absolutely not. Are there going to be a few pieces of evidence that are impacted by this? Perhaps. Will that have been harmless error to analyze it? That's what the judge is going to have to decide. And it's a big decision. On top of that, the thing that the Supreme Court left ambiguous is this something that they can appeal in before he's, when the judge makes the ruling on presidential immunity, can they appeal that, do an interlocutory appeal, which means appeal it before the sentencing, right? During the pendency of the case, as opposed to appealing after the sentence. And that's an open question. And the reason it's an open question is the Supreme Court explicitly said you do have a right to an interlocutory appeal if it was on the issue of presidential immunity on the conduct, right? But this was not on the conduct. This was on the evidence. I know it's a slight point, but they left the question open and ambiguous on whether the admission of evidence that is that tends to be about presidential immunity to prove unimmune conduct, right? Which this is, whether that is appealable. And I think the Manhattan DA's office saw that that's unclear, and perhaps he can do it, and that this realistically isn't enough time to go and all the way up to the Supreme Court, or at least the appellate courts, to determine this. And so the Manhattan DA thought that. And I think Judge Merchan also sees that is a possibility. And so he also, and the reason I think he basically called them out and said, you're not going to put this on me, and I'm going to adjourn this until after the election, is now any decision that is done is going to look political. And it's going to look like it's totally my call. And so, that's why he's just like, look, I'm taking politics out of it, and we'll just put it over until after the election and just let the chips fall where they may. It doesn't bother me as much as it bothers some that they did this, because it wasn't like he could put him in anyway or put him in jail anyway. He's running for president. He's just not going to do that now. And so let's wait and see if he wins, because if he doesn't win, he's going in. I think he goes in, and
I like that. I like that bumper sticker. We're going to give it to Jordy. KFA. If he doesn't win, he's going in. That's perfect. I love it.
But it's true. It's true. And, it's not, because if he does win, there's some little pesky supremacy clause of the United States Constitution. He's not, a little state court judge is not going to be able to do that. So, it's just the reality of things. And Judge Merchan is a practical guy. He sees the reality of it. And so he put it over. But this leads us to the segue of the stay that Donald Trump is seeking in the Second Circuit. What was interesting was their lawyers, Todd Blanche and Emile Beauvais, they were asking for the case to be adjourned until after the election. And they said, because they don't want it to influence the election, right? That was their stated reason, is adjourn the sentence after the election because we don't want it to influence the election. Well, they got what they asked for. But what are they doing now? Now they're going back to the Second Circuit, which is now federal court, right? They're leaving state court. They're going to federal court. And they're saying, I want this case, they're still fighting removal, right? They still want this case to go to federal court. And they still, even though they've lost that now twice through Judge Hellerstein, which is a district court judge in New York, who said this is purely private conduct. This is not anything presidential. And so I'm not removing this case. Well, they want to brief the issue, and they're seeking a stay in the Second Circuit, and they're giving now a different excuse. For the first time they sought the stay, the first time they went to the Second Circuit and sought the stay, what they asked for was when they went to federal court and asked for the stay, what they asked for was a stay so that they wouldn't get sentenced before the election, because it could influence the election. Well, they got what they asked for. Now they have changed their tune. They have literally changed their reasoning and said, okay, well, how we said we didn't want the sentencing to happen because we didn't want it to influence the election? Well, we didn't really mean that. What we really meant was, now we want it to go, we want it to be adjourned until forever, never, and I never want to be sentenced, so that we can take this and meander it through the appellate, because so many appellate issues, about whether this should be removed, whether the immunity decision, this and that. They just want to, literally jerk around in the appellate courts on this made up law of presidential immunity. And so I hope somebody calls them out on it, that literally their reasoning changes, and they do that, right? They just, it's almost like it's misleading the court, is what I will say.
Yeah, I saw that. I know you've got a hot take that's coming up on that very issue. This is just an effort by Donald Trump to inject more delay. There's one of the reportings I read recently that, well, Donald Trump pulled off the inside straight that he was looking for. He got all 4 of his cases either delayed, and even when he got convicted, he didn't get sentenced, and the other case got dismissed. In Georgia, Faudy Willis, shot herself in the foot, whatever. We'll talk about Faudy Willis next. I don't really see it that way. I think the American people, as I said at the top of the podcast, American people have all the information they need to know about Donald Trump. That's why 90% of the people said, yeah, we're good. We know all we need to know about Donald Trump. It's Kamala we want to learn more about. That's why I don't think that the Republicans and MAGA and Trump should take a lot of solace. And that's why I think there's been a misinterpretation of the polling so far. First of all, the debate performance is not part of the polling. It hasn't seeped into the water supply yet. We'll see that in a week or two. But the reason, she had this big, post-convention bump, and now it's moved back to where it used to be and all of that. That's not what we're watching. What we're watching is that even with 30% of the electorate or likely voters not knowing enough about Kamala Harris to make their decision, she's effectively tied or in the lead in the 7 battleground states. Her ceiling, when we talk about a performing artist, a soprano in the opera, or an athlete, their ceiling on their talent hers is off the screen, as you can see by my hand. Donald Trump, everybody knows what they need to know about Donald Trump, right? And so he's not going to get any better. And Kamala Harris is now going to continue to build on a masterful debate performance where she was eloquent and she was poised and she was commanding and all of, as in stark contrast to the unwell, unkempt guy next to her, and the split screen did not help Donald Trump. In the beginning, I was like, wow, he's not moving any of his facial muscles. Maybe he got Botox on top of everything else that he's doing. Then he couldn't, of course, the mask slips. He can't keep it going for that long. And then, of course, that he has, I don't want to do his facial expressions. I'm afraid I'll get stuck with them, but it'll be like, he's got that thing where it looks like he has to immediately go do number 2 in the toilet. This weird face, which he thinks is some sort of retort to her. And they taught him, and this is what lesson he did learn from his prep, not to go after her the way he went after Hillary Clinton, where he remember that round revolving stage where he just started talk about stalking, stalked her like a predator and walked behind her and near her and got in her grill and all that. Well, now they were locked into 2 podiums. He couldn't do that. And whereas, as we showed earlier, Kamala Harris used her facial muscles and her expressions and her, you're not well, man, really? Or tell me more, keep going. We're eating this up, keep hanging yourself, to great effect. He, on the other hand, just had a series of dyspeptic, I've got colitis or an ulcer kind of look, which that didn't telegraph anything other than you're getting your ass kicked. And that's what that looks like. So that's the, but I love the tableau of talking about, the delay issue and how Kamala was able to use that right in the debate. The whole, well, wait a minute, you don't get to talk about crime rates. You're a one-man walking, I think you said it once in our hot take, one-man walking crime spree. You don't get to talk about that. So this is where that intersection, that crossroads of law and politics really comes into our show like this. Welcome back. That was Legal AF. We curate the top stories at the intersection of U.S. law and politics, and we bring it to you here on the MeidasTouch Network, YouTube, and on audio podcast platforms. Just look for Legal AF. There's our album cover, wherever you get your podcast from. We don't blow smoke or sunshine. We're practicing lawyers in the courtrooms that we talk about. Find out what 40 million people a month already know. That Legal AF on the MeidasTouch Network is the home of law and politics analysis and commentary like no other. So if you already know about Legal AF, you're part of our community, we appreciate you. We grew organically with your help. We started with 254 viewers 4 years ago, and now look what we've done together. And so this organic word of mouth build is really, really important to us. So if you know everything about Legal AF, you already caught the episode, take that clip, send it off to people in your life, and ask them to join our movement, to join our network and Legal AF. And if you don't know about Legal AF, that was your first introduction to it. I'm Michael Popok, and I'm personally inviting you to join Legal AF. There it is on Wednesdays and Saturdays at 8 p.m. Eastern Time on this YouTube channel and everywhere you get your audio podcast from. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.